People are slowly coming in, so we'll just wait another minute and then get started.
Lisa, we can't really see you.
Yeah.
Okay.
There we go.
There you go.
About half of everyone logged in so far, so it'll be just another minute or so, and then we'll get started. To this hour that we have scheduled. I am Lisa Ansack, State Director for the Local Bar Association. Thank you all so much for being here today. We really appreciate the time and participation from all of the judges on the panel. Just a couple of housekeeping issues. You, as participants, are on mute, and we don't see your lovely faces, only the judges here. So if there's any questions, please feel free to use the chat box to me. But then for questions for the panelists, for the judges, if you will please use that Q&A box, we will be going through those and addressing those questions.
Lisa, for some reason, your sound quality is pretty poor. I'm not sure if folks are having a hard time hearing you, but you're breaking up.
That's what she sounds like in real life. That's her actual.
Let me, is that any better?
But the first 12 years of her career where she worked at drive-through restaurants, didn't need any training.
If you want to try again, or if you'd like me to get to try that, Lisa. Yeah, let me go ahead. Good afternoon to everyone who's here on this call. On behalf of all of my circuit court colleagues and myself, we thank you for being here to get information today. I read something recently that said, life is full of challenges, and the really exciting part is that we get to choose how we react. And this COVID-19 virus situation has certainly thrown all of us in the legal community a huge challenge. And the 13 circuit court judges have been meeting at least twice weekly, and then of course communicating a great deal in between those meetings to try to develop a new normal for us, a new way to get business done when we have all of the limitations that we have brought on by this virus. In those meetings, we have all been thinking about you, members of the bar who are here listening, and what you're going through in your individual practices, you know, whether you're having to look at furloughing people, or how to meet with clients or conduct depositions, or any things that we know that you do that are so important to keeping justice working. We've been thinking about you and your families at home and all of those challenges. And the firm as a whole felt like it was important that we address you about what you can expect moving forward with court starting June 1, and then, you know, our best look at where we are moving forward. So the goal of this session is for me to give you a brief outline of what you can expect, but we all hope to do a little more listening to you than talking. So after I go through some basic points, both on health and safety side, and then on how court's going to be conducted side, we need to be quiet, and Lisa's going to let us know your questions, and we're going to, you know, work among all of us to answer those questions. Before I go through kind of just some opening points about what you can expect in court, both from civil and criminal practitioners, we know we likely have both on the line. I want to see each of the shining, smiling faces of my colleagues and I. They're all here on this call, and I don't know how your screens are configured, but I wanted them each to have an opportunity to say hello to you, so that you know you have time and attention of all of your circuit judges here as you give us your feedback on what you've been going through and what we're telling you we're going to be doing going forward. So starting with Judge Willett in Division 1, if you'd say hello.
Hello, good afternoon, everybody. Barry Willett, Circuit Division 1. We really appreciate the opportunity to meet with you in this forum, to really hear your thoughts and comments and suggestions on how we can move forward into our new normal. I kind of chewed on a lawyer a couple of weeks ago because he posted something on Facebook saying that we're closed. We have never been closed. The courts are always open. We're just going to have to try and figure out with your help how we're going to move forward safely into our new normal. So I look forward to your thoughts and comments.
Thanks. In Division 2, Judge O'Connell.
Good afternoon. This is Judge O'Connell. I'm excited to, well, not see, but hear from everybody in attendance here today. Excited to hear your feedback and your comments. One of the issues that we've had as a term has been communicating with the rest of the bar. So I'm most interested in hearing your thoughts and ideas about how we can do that and best serve you that way.
All right. In Division 3, Judge Perry.
Good afternoon and greetings from Division 3. Welcome to the new normal for all of us. We're excited you're here. Looking forward to this afternoon's program.
In Division 4 and modeling the new face mask apparel, many of us will see in court. Judge Cunningham.
Good afternoon, everyone. Thank you for being here. I'll just encourage you to ask questions. Don't be bashful. You probably can't think of anything we haven't asked among ourselves, so speak up.
In Division 5, Judge Shaw.
Hi, Judge Shaw, glad to be here. Thanks for coming.
In Division 7, Judge Eckerly.
Good afternoon, everyone. This is Judge Audra Eckerly. Long time no see. We have all been working really hard and coming into work and getting as many cases handled as we can with priority towards the in-custody criminal defendants. And I know you all have been trying to work as well. We've figured out some ways to go forward, but we certainly don't have a monopoly on the ideas, so I'm looking forward to hearing from each of you, and thank you for participating.
All right. Judge Chavan.
Hi, everybody. I'm here. I'm looking forward to your questions. Thanks.
Judge McDonald Berkman is with us. You won't see her, but you will hear her.
Yes, you will. Good afternoon, Judge McDonald Berkman, Division 9. Hope to learn a lot from the bar as well on maybe things we have overlooked or forgotten. So look forward to those questions.
Judge Gibson in Division 12.
Good afternoon. I am not real happy to be on a video platform because it's my least favorite, but it is good to be able to communicate with everybody and look forward to your questions and hoping that we can give you some answers.
All right. And then Judge Bailey Smith in Division 13, also model ask.
Good afternoon, everyone. It's good to be on this forum with you. I wish we could actually see you in person or actually be in court with you in person, but I'm glad we're able to do this way. I'm having some computer issues today, which is why I am joining Cunningham in Circuit 4.
Okay. And let me tell you all, you may or may not have known Judge Brian Edwards in Division 11, who's my suite mate. His father passed this week, so all of our thoughts are with him. And Judge Stevens had a conflict. But I wanted you to know that we're all here and eager to hear your thoughts and opinions. Let me go through some basic ground rules about how we're going to proceed. And then, as I said, we'll open up the floor. I've divided this into two areas, so expectations for court and court attendance, and then building safety issues, because we're all concerned about our safety during this time. As you know, we've had a lot of help from our Kentucky Supreme Court in issuing guidance, so we have some consistency around the state. So pursuant to the most recent Supreme Court order, which is number 39, Circuit Court is going to be resuming both civil and criminal hearings starting Monday, June 1. So our goal is that we're going to continue to have hearings pretty much as we did pre-COVID, with obviously some exceptions. We are being told by the Supreme Court to have a preference for conducting all matters remotely. So everything that we can, both civil and criminal, we're going to be using Skype. We're going to be using, a lot of us, a telephone call-in line. Some of us, and I know in family court particularly, are using Zoom. But all of our preference, as is the guidance from the Supreme Court, is going to be that these things are done remotely where possible. We do maintain some judicial discretion for matters that you may want to argue to us for whatever reason you believe need to be conducted in person. Judge Cunningham has worked to look at each of our courtrooms and talk about how many people can be in social distancing, and I'll get to that in a moment. You can expect that we will be holding hearings in your cases and moving forward in your cases, but the vast majority of that will still be remotely. Our motion hours are also going to begin again starting Monday. Those are again going to be remotely. And we're going to be asking, as you notice, pleadings and motions for our motion hour, that you put in your certificate of service the call-in line and the code that we will each be using for our court, so that you've given notice to the opposing side and parties of the call-in line for that division. Those are all being pushed out by our court administration, and they're on our website that we'll talk about in a bit, and you can get them through the bar. But we're going to be asking you to include those in your notice motion order when you set it for our motion hour. The Supreme Court has also said that, and this is particular to our civil lawyers, that all things that you do to prepare your litigation, including discovery, motion practice, mediation, negotiation, those should be moving forward at this point. I know I heard in meetings I've had with civil lawyers that there's been a little bit of a tension between whether to move forward with depositions, whether to move forward with discovery, whether things are stayed because of this COVID situation. We are telling you, as a circuit term, you have a green light to move forward. We know it looks different. We know you're conducting depositions remotely and doing things remotely, but you do have a green light to move forward. It's our court expectation that you move forward and try to get your cases passed, and that means conducting and responding to discovery, following all the deadlines in our civil rules, noticing things for motion hours when you have problems and you need our assistance. But we wanted to be clear today that we want you to start moving forward in the new way with your cases. An order to attend a hearing in any of our courts remotely will serve just as an order to appear in person. So if you have a notice to appear remotely, then the expectation is, and again, we are all, let me emphasize, we're all new to this technology. We're all new to getting on Zoom, and Judge Chavan has been a leader in getting things done via phone conference. So certainly we're not going to be ogres about the fact that we're all learning the equipment. But we also want it to be clear that since we're going to move forward, that in order to attend a proceeding remotely serves as an order as you would appear here in court. We still, as a circuit term, even moving forward June 1, are going to have limited access to our in-custody criminal defendants. Right now, we have 2 hours a week, which is woefully insufficient. We're aware of that. We're working with corrections and our sheriff to try to find more time. In the near future, we're each opening up an alternate week, one more 2-hour period. But if you have a case on our normal docket with an in-custody defendant, we're going to be looking to see and hear from the lawyers to get that scheduled for one of our time frames where we can have either phone or video capability with those in-custody cases. We know that's a problem. We're working to try to expand that. For right now, and nothing is certain because we have to see what happens when we start in June, the expectation is we'll start back with jury trials August 1. As a circuit term, we are working, all of us together, to talk about how that will look when we start back with the petit juries. We are going to be starting with grand jury, and Judge Gibson is our grand jury judge this month. The grand jury is going to be meeting up on the 10th floor in the appellate level of our courthouse so that they can be somewhat isolated. Judge Gibson will be going up there and taking their reports, but we do expect to be picking up that side of our business again. As we discuss protocols for moving forward with our petit juries, we're looking at things like only calling in a panel per trial. We're probably going to do away with the large 200, 300 person jury orientation. We're going to be bringing those jury panels probably either into larger spaces or in segments into our courtrooms so that we can maintain socially distancing them while we have voir dire. We may need your patience. We may need to be limiting the voir dire questioning because we may be sharing, as a term, some of those large spaces. We're aware of the fact that if we're trying to hold multiple jury trials on the same floor of courts, that'll create some congestion in our halls. And we're looking to all of that. You can expect to hear more from all of us in the future on how those jury trials are going to look. And certainly we're going to see how all of this develops as to whether we can move forward with that as planned on August 1. We do have, and we can all thank Judge O'Connell, we have a Jefferson Circuit Court website now that's specific to us. It's jeffersoncircuitcourt.com. You can go on that and also get information about what we're doing here in our courts. There's a subheading for each of our individual courts where we can upload information. You know, we've all tried as much as we can to give you some uniformity in your expectation. We appreciate that it's frustrating for you that, you know, we all don't do things exactly the same. We all don't conduct court exactly the same. Some of that is good because what works for us, you know, we need to do. Some of it makes it hard on you, but that website should help you ferret through that. To some extent, we all do things a little bit differently, and you all are all aware of that because you practice in front of us. And like I said, we're trying where we can to make it as uniform as possible for less confusion. Foreclosure sales are going to be beginning again for those of you who work on foreclosures. We're working right now to try to find a space outside of our courthouse to hold those so that we can lessen the traffic. But those are the general things you can expect. I'm going to move through this next part quickly and then we'll start turning it over to you. Just in terms of building safety issues, I feel like at this point, a lot of these things you're hearing in other boards and organizations that you're involved in. Masks are going to be required in the building. So if you come in the building as a lawyer, as a litigant, masks are going to be required. For right now, courtroom attendance is going to be limited to parties in the case and lawyers. Normally, we like having interested parties, family members, people who are here to support. We get how important that is. We're going to be limiting courtroom attendance to parties in the case and lawyers, just so you can be prepared for that if you come over to court. Did you need to interrupt me?
They said you needed a cord.
Oh, okay. All persons entering the building are going to be asked to self-report and look at their temperature, self-report if they've been on an international flight. We aren't going to have the capability to test everyone that comes in the building, but the sheriffs are going to be checking with people to be able to monitor all of the things to make sure that those that come in the building are safe. We're going to have hand sanitizer available here in the courtroom. There'll be a cleaning solution provided in the courtrooms. We are going to be asking lawyers who have hearings, if you would please, if you need to use counsel table or a podium, that you use the hand sanitizer and use the court cleaning equipment for yourself to be able to clean up your workspace to help keep yourself safe. That's also because we don't have the facilities personnel here in the building to clean up after every lawyer's argument. We also like the fact that we're all stewards of this place of justice and that we will all be responsible for helping to keep it clean. Social distancing will be required in our courtrooms, and we're having our sheriffs measure and put places so that we can visually mark for you. If you stay in those places, you will be 6 to 8 feet away from anyone around you. There'll be a limit of 2 people on the elevator. So you need to make sure when you're making plans to come over, if you do have an in-person hearing, that it's going to take you a little longer to get through the building, both for the bottleneck that'll happen coming in and then limiting the elevators to 2 people per elevator. The clerk's office is operating on staggered shifts with 50% of their employees. And I'm letting the bar know that because we've noticed, and you'll notice, that there may be some delay in processing and entering our orders, both on the criminal and civil side. Normally, we're pretty speedy about that, and we're going to be seeing some delays, and we just want to ask for your patience and let you know that that's going to be happening. There's going to be a strict limit to how many people can come in the courtroom at any given time, and we're going to be asking you again to practice social distancing as you wait in the hall. In early days, we're hoping to have some sheriff support to help remind folks to do that. We know when you come into court that it's an emotionally difficult time sometime. So just to have people helping to remind you to stay distant from other people so that we can try to ensure safety of the participants in our justice community. There's a lot more that we've talked about and worked on And let me just assure you that it wasn't just the 13 of us. I've been participating in a statewide committee that has judges from all of the 7 Supreme Court districts and representatives of clerks. We also have a Jefferson County reopening task force. The health department has come down twice and gone through our building to give us recommendations. We've also had recommendations through our state health department, as well as being in contact with the city of Louisville through Mayor Fisher's office and the state of Kentucky through Governor Beshear and the executive branch. So there has been a lot of thought, a lot of support from our Supreme Court, a lot of support on the legal issues and confrontation issues and other things from our statewide administrative office. So I want you to know there has been a lot of thought. I want you to know how thoughtful and concerned all the members of the circuit court have been about what's going on, about the somewhat limited access. We're all eager to get you all in your cases moving. And so those are some of the things that you can expect. I'm sorry to be a talking head for so long. But what I'd like to do is open it up. And Lisa, hopefully you've gotten where you can have a little better audio to let us know some questions. And I'm probably going to be directing those around to myself and all of the colleagues that are here to give you the information you need. So Lisa, I'm hoping you've been able to work out the audio.
Here's something. Can everyone hear me okay now?
Mm-hmm.
Okay, so the first question that we have, HB 356 included language that may have extended the state of limitations during the current COVID-19 shutdown, but it is unclear. Have you all received any instruction regarding an extension of any statutes of limitations?
So I can answer that. There was a budget bill passed that I believe included some language. Are you looking for it, Judge Willett?
No, I was looking for something else.
We didn't, as you all are aware, we didn't blanketly pass all civil deadlines or rules. The Supreme Court has directed us to use our discretion given the circumstances, but I believe in the budget bill there was an accommodation made for statutes of limitations. I don't have that language right in front of me. If any of my colleagues do, feel free to chime in.
It looks like the next is, how would you like attorneys to address a timing conflict if we are scheduled or noticed to appear on different matters in different divisions or jurisdictions?
Your audio is still pretty poor. I'm wondering if you could call in maybe on a landline.
Angela, can I take this question? I'll repeat it.
Sure.
Sarah has a good question. How would you like attorneys to address a timing conflict if we are scheduled notice to appear on different matters in different divisions or different jurisdictions? My suggestion is just like you would normally otherwise, this probably applies more to the criminal bar than it does the civil bar, because the criminal bar has multiple hearings each day in the different divisions. My suggestion is that most of you probably have the telephone number for the deputy in a given division. My suggestion is just text or call that deputy. Let them know that you've got another conflict and that you'll probably be coming to the hearing in that division a little bit later. I think they can let the judge know, and we'll certainly accommodate that.
I would also suggest that at the point of accepting a date, when the hearing or appearance is being scheduled up front originally, and having been a public defender myself for a number of years, I know the challenge of getting to at least in circuit court, potentially 13 different circuits at once. I would suggest maybe padding your calendar a little more than you ordinarily would under these circumstances. And of course, informing the court and court staff if you've got a conflict and need another date.
Anyone else want to weigh in on that? Judge Willett, if you can see the questions, maybe you would be a good questioner because I can hear you pretty well while we're working.
If you look at the bottom of your screen, you can click on Q&A. It shows you how many active questions there are. I'll be happy to read them.
Sure.
David has a question. In light of the need to include a new certificate of service with phone and code numbers, must all motions for motion hour be read? In addition, will we need to contact the clerk for a date and time prior to submission of the motion? there. I asked the question, somebody else can answer it.
I can tell you what we're doing here is I've just been, if it doesn't have the certification with the numbers, I've just been sending out a notice continuing to the next date with the numbers. That seemed to have worked so far with the civil cases because I don't have that many, frankly, compared to what we'd ordinarily have. With the criminal cases, it's less important because the public defender's office, which has a majority of the cases, the Commonwealth Attorney's office, which has all the cases, knows to call in or have a representative there. So for criminal cases, it's far less important as long as somebody is there to cover it. In civil cases, it really isn't good notice if the person doesn't know how to be there. So it would have to be continued either by the court or through a pre-arrangement with the other side. If you call the other side and just make arrangements to be there and then let the court know, they'll call the case.
But I think to answer the question, I don't know that you need to contact, at least in my division, you don't need to contact the staff to get a date. You would just give your motion as you normally would and include that information so that both parties have the call-in line where I'll be calling the case. I agree with Judge Chavan. If it's not included, I'm likely to roll it to make sure everybody's given that information. But in terms of contacting staff to schedule the motion hour, I think you would just notice it the way you normally would.
I see another, excuse me, I see another question out there from somebody that I'd be happy to take. There's somebody who wants to know, it looks like maybe Dustin Meek, at times counsel monitor cases and attend hearings. Can counsel still be open to, are those hearings still open to the public by other means, and can counsel who aren't the counsel record appear? The answer is yes. Obviously not to come into the courtroom physically, but there's always the video that you can obtain from the clerk's office after the fact. That's still going to be available. All of our hearings are public and you can do that. And with the new teleconference matter that Judge Chavan set up that we're all going to be using in motion hours and hearings, you can participate in that hearing telephonically and listen to things as well. And so can the other people that will be barred physically from the building, such as people, court groups and families and people of that nature.
And I think IT has also discussed, at least statewide, the possibility of getting to the point where we're live streaming, whether that's on a YouTube channel or some closed network. But I think that's on the horizon.
Similar to how we can all go and watch the Supreme Court, the Kentucky Supreme Court sends out an agenda of their hearings and they live stream. Told by AOC that that technology is available. Also been told by some participants that it may be difficult given the volume that we have here in circuit court, but we're looking at that. And as Judge Eckerly said, until we have another method, we're allowing individuals to call in who have an interest, so they would be here virtually like the participants. Obviously, we would want them to be and not to contribute, but just to be able to listen.
There's a question about how will the record be kept. We will simply have our JAV system on when we're on the record. It will pick up audio. The video will be a boring picture of the bench, but and you can order those just like you would if you were here in court.
So it looks like there's another question that says, when do we anticipate that the jail will begin transporting in custody criminal defendants? Will there be certain types of hearings where that begins first? They have concerns about our ability to privately converse with a client during the course of a proceeding.
You know, we're all concerned about our inmate population right now. We all believe that people need to be held accountable if they break our laws, but when you're held captive and it's similar to a nursing home situation, you know, you have a group of people, we're all concerned about that. And we're not, you know, it's that delicate balance between people's due process rights. We want them here in court, but we don't want to be making decisions that will put them in any greater harm's way or the workers that are there with them. So Steve Durham and Dwayne Clark, who are the directors of corrections, are on both our statewide and our local reopening committee meetings. They're giving us updates. they do have a process within corrections where if, people are being tested and certain that have been around anyone who's tested positive or kept isolated, even to the point where they're not bringing them over right now for court hearings. As I said, they aren't ready as of the June 1 date, and it would certainly make all of our lives a little easier if we could bring them out into our courtrooms again. Listen to the medical professionals on that, and I want to listen to the folks that are on the front lines in correction. So for right now, our game plan is to try to get more access and more hearing availability. Say for June, we're still looking at them not wanting to interface people that are in corrections, bring them out into a courtroom where they're potentially exposed to more people. We don't have a date certain when that's going to open back up. I know they're looking at when numbers go down for the community on the whole, and then where they're not as where there's less concern about a spread in corrections. So that's not something that you can look to see change, I don't think, in June. And I think we'll continue to monitor the situation month by month. We want them back out in the courtroom for these important proceedings as soon as possible, but we also want to balance that with having it be done safely, both for the attorneys that represent them and for the the folks that work there in corrections. So I don't have a solid answer for you. I can tell you that people involved in that are involved in all of these meetings, and we'll push that out as soon as we have the information, but I don't think it's going to be in June.
Can I address the part about the private conversation, which is really important? The audio, the teleconferences work really well, except when a lawyer needs to talk to their client about something privately. So the jail has accommodated that, I think, very cleverly. They have a separate line, and you'll want to know what that number is. And if you don't have the judge will, that you can call in and talk to your client off record privately if he or she has a question. So that has been addressed with teleconferences. There is a way to do that. And if you're unsure and if you need to do that, just ask during the call, and the court can probably help you facilitate that.
Let me address a question a good question that Culver has asked. Have any of the judges held a bench trial of a civil action since the pandemic began? If so, any issues? I'm not aware of any judge conducting a bench trial during that period of time. I'm going to refer the attorneys to two very important orders. If you haven't read, you should. They're both administrative orders issued by the Supreme Court. The first is 2020-39. That was issued on May 15th. The next one is 2020-40, issued on May the 19th. And those orders dictate to us as trial judges that although we're hoping to resume jury trials on August 1, in custody criminal defendant trials shall take priority. So I guess I want to tell you that because I want to temper the expectations of the civil bar to understand that this is a directive to make sure that the rights of the criminal defendants are protected. So that will be an issue to everybody moving forward. The backlog is going to be incredible. It's going to take us months to get through it. And everybody's just going to have to be patient.
And there's a similar question about the August 1st date. And like Judge Bissig and Judge Willett have said, we don't know what's going to happen with the virus going forward either. So while we all hope to start trials on August 1st, that's not firm. The virus is going to control our response to that. And there's a possibility we may, there could be another shutdown. So we're all hopeful that we're going to begin jury trials on August 1st, but we'll have to see what happens. And then when we do, it's going to be only in custody criminal defendants for some time, especially since everybody on the floor, we're on a floor with 3 other courts. Not all 4 courts can go forward with the jury trial at the same time. The space in the hallway doesn't allow it, but we also have thought about we can't even send all of the jurors on a break to the restroom at the same time because that's not enough social distancing. So we're trying to figure all that out too.
But you should not assume, in answer to that question, that if we have civil trial dates in August or September, should we assume that those trials will be rescheduled? No. You should assume that they will go as scheduled, and that's part of the Supreme Court order says everybody should be proceeding as if everything was normal in terms of your preparation, your litigation, in terms of discovery and depositions and all that goes on as near to normal as possible.
And one of the things that I have seen is that a lot of things have screeched to a halt. I think for a period of time, mediation stopped. Nobody was going, depositions stopped. And the Supreme Court has been very clear to us that the process of litigation must go forward. Depositions need to be taken remotely if necessary. Mediations need to go forward remotely if necessary. But you have to continue to make progress on the cases. And most of what you do outside the courtroom anyway. So
you keep in mind, if you're particularly a civil litigator, some things you could do, you could entertain a bench trial. I would always acknowledge that a jury trial is probably preferable, but you could, in these circumstances, you might entertain a bench trial. You might entertain the idea of a 6-person jury rather than a 12-person jury. A 6-person jury is easier for us to manage in some of our courtrooms. So,
and I would disagree with that. I would not be inclined to agree to any proposal to reduce the number of jurors.
Well, I wasn't talking to you. I was talking to
Charlie, you know I'm very opinionated.
I understand, and I'm acknowledging it's not as good, but if it's a way to get your case heard that's doable, you need to start thinking outside the box.
Things by agreement.
Yeah.
Well, and to echo what Judge Chavan said, the Supreme Court is directing us to give preference to in-custody criminal defendants, and you can imagine why. They're innocent till proven guilty. If they're in custody, they need to have the day in court, and they need to be given priority. But I agree wholeheartedly with Judge Chavan. We're going to be working together more than we ever have to try to schedule things, and we're all going to be given priority in those in-custody cases. But, you know, if anyone else on the 9th floor where I am is having a trial and I have a civil trial ready to go and it's in August, I would try that case. And so for the civil practitioners, although it's disappointing to hear that we're pushing it out to August and maybe thereafter, and that the criminal are taking priority, I would check with your individual division before assuming your case isn't going to go forward. Because like I said, we're going to have a lot of coordination that we usually don't have to have in planning these. And we're going to be giving priority to in-custody criminal. But if it's available and we have time, we're going to, start the civil trials as well when we can. So just so you know that, I would check with your individual division and see what's going on their schedule.
So there's another question in regards to how to handle pro se litigants having access to the clerk's office. It appears that there's been some challenges in regards to a garnishment with a client.
So I know from my meeting this morning, Dave Wilson said if there's somebody who can't access CourtNet or can't access e-filing and they need to physically see a file, they can call the clerk's office and make an appointment to come down and physically see a file. I don't know that they're allowed, as they would be during normal time, to walk in the building and go and see a file. And again, they may need some patience, but they can call and make an appointment to come down and physically see a file.
So the next is there a uniform procedure you all would like public defenders to follow for ex parte Chapter 31 fund requests?
Charlie? Yeah, I think file a motion. Just put it on the motion hour, and then we'll schedule the hearing, the ex parte hearing at the motion hour. But you still need to file a motion just like you normally would.
Well,
I don't think we all require that.
Yeah.
That may be Judge Chavan's practice.
I think without it, you head into some of the issues that they were unhappy with.
I would just respectfully disagree, and I would just ask that you call the court, the administrative assistant in my division anyway, and schedule a time.
Same for Division 2.
3 as well.
Yeah. So that takes us to this important point. There's a theme here on questions about why can't we be consistent? Because we can't any more than Oldham County, Shelby County, and Nelson County can. You know, these are 13 different divisions. There's 13 separate entities, and everybody has their perspective on how things should be done, and they're all legitimate perspectives. And it does make it harder for the litigants, but as Angela said, probably better in some respects, because you're not stuck with one way of doing things. So that's why that jeffersoncircuitcourt.com is so important. If you go there, you can get information about how it is each judge wants things done in their particular jurisdiction, in their bailiwick, as it were. So go to that, and then go to the link to each individual judge. And maybe the one thing that's not intuitive is you might need to hit the more information button, is where probably most of the information you need. There's contact information on the judge's page, but the things that they want you to see specifically might be on that more information button. But you just got to do that, just like you do if you practice in more than one county. You're just going to have to make that extra effort to see what that judge wants. But we have made serious efforts to try and be as consistent as possible, where possible, to make things as easy as possible for you all. But there's just some things that are just not going to give. And that's a small but good example that I would not accept a phone call on an ex parte hearing. You'd have to put a motion on to set the hearing, and then it would be ex parte.
I would add not to be shy about emailing all of that. Those websites have our court administrative staff. And especially during this time where you can't come back or push on the button or come back to our chambers, I would not be shy about using the administrative staff information. If you have an issue or a question, I would be shy about emailing the judge directly. We've all had a little bit of that during this, and we get nervous because we don't want anyone to, our goal is that everyone's on an equal playing field and an equal footing. So now really want to get an individual email from you asking a question about a case or how it should be handled. But all of us welcome our staff getting that email about, are you having motion hour or other issues? We're telling you all now we are, but it's okay to email our staff with questions, or to jointly email with the other side and say, we jointly this or need a hearing on this. We encourage you to contact our staff for that kind of information too.
And to follow up on that point, I don't know if you all are aware, but we don't plan to allow people to buzz back into chambers. There are a large number of people that want to come back into chambers every day, and it's just way too much exposure. So you'll need to call or email or text staff about what your needs are.
Can I say one thing about that too? And I agree, there's a couple problems that have come up with that. One is that they're calling first before reading the order, for example, that probably gives you the answer. So please make sure you read the order, and then maybe go to that website first to see if it gives you direction, because our staff is not here all the time. They're also in half time. So my secretary is not here every day, and you're going to not get the answer immediately, and she's going to get overwhelmed with those calls. If you can self-screen by trying to find that answer first, you might find that it's there either in the order or on the website.
Okay. So there's another question asking, will summer associates or law students be permitted to attend any in-person hearings with attorneys?
To the extent there are in-person hearings, sure, as long as it doesn't exceed the permitted number of people in the courtroom and the judge signs off on anybody being there, you wouldn't be excluded per se. I don't think. Anybody disagree?
I think by extension, they're considered part of the attorney's office. And that'd be like bringing a paralegal or your associate.
Right.
They should have a mask. They should be, they'll have to sit 6 feet apart, so they can't be like, hey, why did you do that? Until he gets outside in the hallway.
Okay. So then the next question says that you stated that foreclosure sales will resume next month, possibly at a new location. Is there a time frame for when the sales will resume?
We don't have a location yet, so I don't think there would be one starting June 1. We are working on it. The restriction on not having them that's been in place will be lifted, And I think it's just going to be the logistics of figuring out where and how, security issues, and being able to fit the number of people that often appear for Jefferson County sales. And Carol Schneider, our Master Commissioner, is working on that. Carla Kreitman, our Circuit Court Administrator, is working on that. We've had some options. Some of them have fallen through. I would imagine as soon as we can find a location, she'll start sending out those notices, and those sales will be up and running. But I can't, unfortunately, on this conference today, tell you where and when the first one will be.
Okay. So then for in-person court hearings to enter a judicial building, will a temperature check be required? If so, how will they be conducted? Non-contact infrared thermometers, infrared cameras, etc., and who will conduct those?
So we looked into technology. We realized the importance of screening, and we looked into the technology of having, big scanners that people can walk through. Everybody who practices in this building appreciates the volume of the Judicial Center and the Hall of Justice. I've been told many times we are the most populated busy building in the state of Kentucky. So we looked into the big scanners. They were cost prohibitive. Through the administrative office of the courts being provided some handheld temperature taking ability, but I don't think, or I know that that's not going to be done with every person. There's going to be signage. We're controlling the entrances, so there'll only be one entrance through the 6th Street side of the Hall of Justice, and then through the normal entrance. They're trying to stage off so that the people entering and exiting aren't in the same flow of traffic to make social distancing. And there'll be signage at the entrance of those doors stating reasons that you should not be coming in the building. The will be there to take an individual's temperature if there's reason for concern. Asking ourselves and our staff to self-health monitor before we enter the buildings. We'll be asking lawyers to self-health monitor, but we will not be having a global temperature taking upon entrance to the building.
So in that same question, they also asked what criteria will be used to deny someone access, and if they're denied, how will this be communicated to the court so a person is not held in contempt for failure to appear?
I can answer that, but I can let somebody else. Judge Perry, you want to answer that since you're...
Well, if I understood the question correctly, the preferences for remote virtual telephonic hearings, and if you get notice that you need to be here, you need to make yourself available that way. And at least for me, we would give you the benefit of the doubt once, twice, 3 times if we can't find you, because we know it's a new normal on how to contact us. To echo a couple of earlier comments, it's critical that you look at our new website and find the contact information. Our staffs are going to be mostly communicating by email often, so don't hesitate. On that note, I just got texted a question from a lawyer I know personally that asked about what about everything that's been pending by way of civil dispositive motions. I think, at least in my division, I think we're mostly caught up. If you have a question about a pending case, I would urge you strongly to contact us to ask about what's pending and ask to be heard telephonically or ask to be heard in person if it's absolutely necessary. But with regard to contempt, I can't imagine that any of us are going to be anxious to hold anybody in contempt anytime soon.
So if they appear at the entrance of the building and they have a temperature, they've traveled internationally, someone in their family has been tested positive for COVID or themselves, and they're denied entry by the sheriffs, we've all been really concerned about that because of, if they're trying to do the right thing, trying to get here to court, but they're denied access for whatever health reason or other reason. We've been told the sheriffs down working the mags will be able to radio up to the sheriffs working in our individual courtrooms and let us know John Smith tried to come to court today, he's been denied, and so that we don't issue a bench warrant for that person. So it's going to require communication between our bailiffs and our sheriffs. Go ahead, Judge Spann.
No, I was waving to Bill Adams.
Oh.
Saying goodbye. Did you all want to say goodbye to Bill Adams? Anybody else?
Bye, Bill.
Everybody says bye, Bill. Thank you all.
So we're hoping to coordinate communication that way.
We're getting ready for Rocket Docket.
There was a question I saw where somebody wanted to know if they get the phone numbers for our sheriff's deputies. I perhaps them and I've started to put that on my contact information for my division. And talking to my deputy, we chose not to do that because it is literally his cell phone. We don't care to put that in a publicly available location. I think most of the people who routinely come to my court, and I'm thinking public defenders, assistant Commonwealth attorneys, they probably have Bill's cell phone number, and he probably has theirs. Publicly telling you our deputies' cell phone numbers, we're really not going to do that. But if you come and you need it and share yours, he probably would be amenable to that. But that's not something we're going to put on the website where the whole world would know his cell phone.
And the answer that I prematurely typed in response to that question conflicts with Charlie. But Charlie makes a really good point. And if you want to get my deputy's cell phone number, feel free to contact my court staff and they'll ask for his permission and pass it along to you.
Yeah. Lots of people have it, but we don't want everybody to have it.
So another question that we've not addressed is how will interpreters be utilized given social distancing?
We've done them on the phone, and it's fine. It's a little harder than it is in person. And one of the interpreters pointed out that it's hard because she couldn't see the person's face, so it was harder for her to interpret. But it worked out fine. We had one actually that was in Swahili, which was fascinating. So it works out fine. They just call in like everybody else on the line.
I've had several hearings utilizing them as well, and Judge Van is right. We use them. It's a little more cumbersome, but we just use them on the same line as we're communicating with the lawyers. It looks like we have maybe about 4 minutes left. So, Lisa, I don't know if there are a couple or any questions that are repeated. Any final?
There is a clarification that someone is asking. Civil motion hour will resume June 1st, and will it be held telephonically on Mondays at the regular scheduled time? Everyone is shaking their head yes.
The answer is yes.
Yeah, let me try answering that first. My initial thought a few weeks ago was that because I'm Division 1, I go first with motion hour at 8:30 on Monday mornings. My intent was to hold motion hour live after getting one of the two most recent Supreme Court orders that told us to, for all intents and purposes, conduct everything remotely. I decided that motion hour in Division 1 will be conducted remotely. So call-in number is on our Jefferson Circuit Court website. All you have to do is log into that service. It's free. Conference USA, a third-party vendor, and each court has a specific ID that you have to plug in to get onto that conference call, and it's the one that Judge Chavan started out and has persuaded all of us is very effective. So that's
one difference we're going to do in Division 7, because I was concerned that we would have a stampede of people filing motions and noticing them for June 1st. So I've been ferreting them out on the civil side only. And if I can get you a hearing date, then I've just done an order remanding it from the civil docket, which hopefully you'll receive timely, even though we have half clerk staff, and giving you another hearing date, which would be telephonic. So some of the motions I may not get until that morning, so I'll conference those by teleconference. But since we had such a huge civil filing for June 1st, I'm trying to divert as much of that as possible so that our motion hour will be small enough that you'll be able to get to the next motion hour for the next division when you're supposed to. But it will be remotely.
Okay. So I think another question that I see is, have you identified a suitable method for dealing with hearing exhibits? And perhaps a later webinar could be scheduled to educate the bar. Is there?
I've thought about this. I don't know if you guys don't mind if I chime in. I will probably have a simple Dropbox where people can upload documents that I will view at the appropriate time during a hearing. If you have an in-person hearing, I've designated a spot in my courtroom where you can deliver documents or evidence remotely and place it there, walk away. Once you're away, I'll get up and retrieve the document and view it.
Yeah, and on these platforms, I think we're all going to be creative, and we're going to, as we do it, as we conduct more and more proceedings, we'll be creative. But there's the screen share function on this that I have seen used in a number of meetings. I agree with Judge O'Connell that we will probably facilitate some manner in which we can pass the papers without having to be 1 foot away from each other. A spot where they can be left and where the judge can pick them up. And we're all just going to have to be creative about keeping the justice wheels moving with these new constructions.
I think that pretty much answers the majority of the questions. If we've missed any, we will review these and get the questions out to the judges for a summary, and we can publish those on the LDA website and or social media. We have recorded today's program, so that will also be available on the website. And just as a note, there was a question about if there will be a district court panel, and that will be on Tuesday, June 2nd at 2 o'clock. So should you want to register for that, the link is available on the LBA's website. So with that, judges, do you have any closing comments that you would like to address?
I would just say on behalf of the circuit term, we all appreciate your time today and coming and listening to what we have planned. We welcome your input after this session via email. You can email me or any one of us. We are still meeting very regularly, so we are all in a forum where we can discuss your ideas and input. If any of you have a great idea, we are open to hearing it. Like I said, we will be patient with you. We ask your patience with us as we all try hard to move forward. I think your takeaways from today are that we are trying to move forward in a somewhat normal procedure, with most of it being done remotely, that you may need to wait a little bit on things to be entered because we still aren't fully up to speed with what clerks are doing, that we're going to continue to give health a huge priority in what we're doing, but yet try to administer justice as effectively and fully as we all can. The other takeaway is for the civil lawyers. We've heard a lot that there's a lot of stop and start and stalling. We're asking you to go ahead and move forward, practice your cases, bring motions before us, hold your depositions, exchange your discovery. We wanted to be sure and get that message out because we were hearing a lot of frustration from both, from defense and plaintiffs' counsel about what they should be doing. So we wanted to give a clear answer to that as well. And we're here, we're available. Unfortunately, it's not in person like it normally is. And we're thinking about you and your families and your situations as well. We want you to know that.
Okay, so it looks like we're over just a little bit on time, but thank you, judges, for your time and your willingness to meet virtually. We sure appreciate it. We miss everybody at the Bar Center. Feel free to send us emails and check out our upcoming programs and webinars that we also have. So with that, we will close out. Thank you again.
Thank you. Thank the Bar Association.
Thank you.